Thank you for joining today's webinar. We're excited to cover a topic that I believe is woefully underexplored and something that many of us struggle with personally: digital inheritance. This event is sponsored by Vault12, who has recently joined the Chamber of Digital Commerce and delivers a security solution for protecting digital assets such as cryptocurrency seed phrases. I'm excited to introduce Jason Letterman, who is a senior associate at Norton Rose Fulbright, a valued chamber member, where he focuses on providing counsel to high net worth individuals and clients concerning all aspects of estate planning and trust administration. Jason is going to chat about important considerations as it relates to estate planning. Jason, over to you.
Thank you, Patrick. Hi, everybody, and good afternoon. My name is Jason Letterman, and I'm a senior associate in the Trust and Estates Department at Norton Rose Fulbright in New York City. I'm admitted to practice law in New York, New Jersey, and Florida. I specialize in creating and implementing estate planning and tax saving plans for high net worth individuals. A good portion of my practice is devoted to cryptocurrencies and folks who have accumulated them and would like to know how to pass them on to their children or other folks in their lives. There's an interesting quip about T&E lawyers that we're the world's only surviving traditional lawyers. And we are traditional in the sense that while we specialize in complex tax issues, trust administration, probate matters, we need to know a little bit about everything, or almost everything. If our clients own real estate, we need to know something about real estate law. If our clients own cryptocurrencies or are crypto investors or are crypto creators, we need to learn about these assets, how they work, and how they can be transmitted from one generation to the next. And so I've been asked to give a few introductory remarks concerning the subject of digital inheritance. I'd like to thank the Chamber of Digital Commerce and Vault12 for asking me to join you here today. In the short time that we have, I'd like to just give you a basic sense of how assets, and more specifically cryptocurrencies, are dealt with in the probate process, and perhaps leave you with a few fundamental important ideas to keep in mind when thinking about your digital estate plan. The first thing to note is that each state and each country has its own rules. There's no one-size-fits-all approach to estate planning or thinking about planning with your digital assets. This is particularly true when it comes to cryptocurrency. Several states, including New York and Florida, have passed laws to try and deal with the ever-changing digital asset landscape. In these states, it's generally clear that a fiduciary, in other words, usually an executor of an estate or a trustee of a trust, has the ability to control certain digital assets that once belonged to someone else. Unfortunately, or fortunately, digital assets and cryptocurrencies continue to change. And so even legislatures that try and keep pace have a tendency to fall behind. As a result, there are enormous gaps in the law when it comes to digital inheritance. Perhaps it goes without saying, but I'll say it anyway. If you're dealing with inheritance questions surrounding digital assets, you need to consult a lawyer who understands this stuff. The field of inheritance law is one of the oldest, most antiquated, most ceremonial areas in legal practice. And when you add in the complexities of cryptocurrencies, there are many traps for the unwary. There's no substitute for competent advice in estate planning, and there's no substitute for competent advice, especially when it comes to cryptocurrencies. There are a lot of pitfalls. With that said, I'd like to just take one moment and give some general background on the probate process and terminology. Generally speaking, when a person passes away with a will, he or she is known as having died testate. If a person dies without a will, he or she has died intestate. When someone writes a will, he or she has the opportunity to designate his or her executor in the will. The process essentially is as follows. When somebody passes away, the will is presented for probate, which is essentially the process of proving that the will is what we think it is, the last will and testament of the testator. In that proceeding, the executor is officially named by the probate court. As previously noted, the executor is a fiduciary. In other words, the executor is tasked with carrying out the wishes of the testator, the writer of the will, as expressed in the will. He or she owes fiduciary duties to the beneficiaries of the estate. These are enforceable rights. One of the primary functions of the executor is to gather the assets of the estate, or marshal the assets, as some lawyers say, pay creditors and tax authorities, and then distribute the remaining assets to the beneficiaries. Of course, the executor will need to know what assets exist in order to do this, which brings us to perhaps the most important and easiest part of the estate planning process that a lot of people actually miss, and that is creating an inventory of what you own and what you owe. An estate inventory, which we sometimes refer to as a personal net worth statement, should be detailed, and it should provide information about how to access assets. For traditional assets, this inventory would include bank account information, approximate balances, a description of interests and entities that you own, attendant rights to those interests, real estate. Today, this inventory may include private keys, keywords, passphrases, passwords, and logon information, all of which, as everybody on this call I'm sure knows, is extremely sensitive. The problem here is writing this information down and leaving it in a folder in your home exposes your assets to a direct risk. The security issues presented with cryptocurrencies are much more significant than with other assets, because mere knowledge of the keys is essentially a deed to the property. Ordinarily, in the law, we have external proofs of ownership, such as a title document or an account name. With your private keys or other sensitive digital information, anyone who has them can take your assets, and they may be transferred beyond the practical reach of any legal system almost immediately. There are various approaches to dealing with this security challenge. Some people trust one or more business associates, their named executor, or another third party with their keys and passphrases. Information can be divided or encrypted to keep everyone honest. Others develop a safe deposit box methodology to store information like this, whereby a key is left in an envelope with instructions for the executor. It might involve encrypted documents stored on a hard drive and backed up to a cloud. And there are, of course, various technological approaches to dealing with this security versus access problem as well, as you will hear from Wasim. The takeaway is that you need a plan that is thought through. You need a secure way to provide your fiduciaries access, but without taking risk of loss. The greatest catastrophe would be to spend a lot of time accumulating cryptocurrencies and thinking about how best to pass them to your beneficiaries, only to lose them in the ether, no pun intended, due to an oversight or a contingency that was not spotted. Accordingly, the ideal technical approach needs to have several attributes. First, it needs to be accessible so that you can update your data on an as-needed basis and as it changes during your life. Second, it needs to be secure so nobody else but you or your designees can access that data. Third, it needs to be customizable to your needs and readily amendable so that you can revise appointments as they may change during your life. Fourth, and perhaps most importantly, there needs to be fail-safe measures in place to ensure that if something does go awry, such as the untimely death of a designee or a beneficiary, your information cannot be irretrievably lost. We've all heard stories about cryptocurrencies that have been completely lost because the keys were gone, because the hard drive was lost someplace. Significantly, and also extremely, maybe also the most important part here, is the plan needs to be continually maintained and reanalyzed in order to make sure that your current wishes are reflected. A plan is only as good as its implementation. Now, of course, I'm describing to you an impossibly ideal plan. An actual plan might involve several of these tools. It might involve funding lifetime trusts, revocable trusts or irrevocable trusts, and imposing fiduciary obligations on the trustee of those trusts, who can be tasked with a legal obligation to safeguard the cryptocurrencies. It might involve a technological solution such as Vault12, or it might involve some elaborate combination. These are really all tools at the disposal of an estate planning attorney and a client wishing to solve these problems. The real point is that if a person has accumulated substantial cryptocurrency assets, he or she needs to sit down with advisors who understand these assets and who can build a decision tree and make sure that all aspects of the plan are fully developed. With that, I'll turn it back over to Patrick so that we can talk a little bit more about the technological solutions that are available.
Thanks a lot, Jason. That's super helpful framing, especially for those of us who haven't lost our digital assets in a tragic boating accident. This next portion of the discussion, I'm really excited about. I'm going to turn it over momentarily to Wasim Ahmad at Vault12. We've been having a lot of conversations with Wasim and the Vault12 team recently, and have grown quite fond of the group there. On our end, one thing that I want to cover for the audience here is in this next segment, we definitely want this to be an engaging discussion and to engender outcomes that you're here for. So I definitely want to encourage you to use the chat function or the Q&A function here to ask questions. And Wasim and Phil will certainly try to address that throughout the remarks and then at the end in a Q&A period. So please leverage that. Again, we want this to be informative to you. Wasim, I'll hand it over to you at this point.
Great. Thanks very much, Patrick. And thank you so much, Jason, for joining us today and setting the scene. We're going to hear back from you in a little bit for the Q&A section. So stay on the call. Hi, my name is Wasim Ahmad. I am with Vault12. My background is in cryptography, e-commerce, those kinds of areas. I'm not a lawyer. Both my brothers are lawyers, or in fact they're barristers, but so I do know the value of getting good legal advice. And if there's one thing that you're going to hear from all of us today is that you do need to get good legal advice to set up your estate. So with that, I'm just going to switch over to my slides. I have a couple of slides that I'd like to go through in describing Vault12 and what Vault12 is. So what is Vault12? So Vault12 is an app that we launched earlier in the year that secures your digital assets. And it dramatically reduces both the risk of accidental loss, and there's been many cases of accidental loss in recent years with wildfires and flooding and those kinds of things, as well as the threat of criminal theft. And the technology works by leveraging a personal trusted network that you designate, so people that you know, to actually protect your assets so that they are never stored in one place, either in the cloud or locally. They're actually distributed. So that's kind of the premise on top of which we have built a digital inheritance solution. So I want to talk about sort of some of the statistics that exist in this area of people who are very crypto savvy, but how that correlates to whether they actually did their estate planning or not. So a lot of people worry about dying, having crypto assets and then dying with them without a clear path to where they go and who can access them. And so that number is very, very high. And unfortunately, only less than 25% have a plan, and only 7% have created a will. And one of the things that I found out when I was kind of researching, to prepare for our launch last week was, while you'd expect that there were lots of examples of older people dying maybe without a will or without making the appropriate arrangements for their cryptocurrency, it actually turned out that the biggest examples of kind of bad scenarios were all young people who, for whatever reason, had some kind of misfortune and passed away, and no one could get hold of their private keys or their seed phrases, and so were locked out. I think the largest example is actually Matthew Mellon, the heir to the Mellon Bank fortune, and he died at the age of 50. He had done a very good job of protecting his crypto assets, which totaled about $1 billion, by dividing them up, putting them in cold storage around the country in different people's names. So from a security perspective, he definitely thought through. Unfortunately, from a leaving instructions perspective, there are no instructions. There's no way to backtrack and figure out how to get into those cold storage accounts. And so those that $1 billion of XRP is out of reach, unfortunately. So creating an estate plan, creating whether it's a will or whether it's a living trust, and we will get into that at the end during the Q&A, is very, very important. So the question becomes, well, how do people who have been investing in cryptocurrency and other digital assets, what are they doing today? And so what we find is that people leave instructions in the household somewhere. So it could be a piece of paper, it could be a folder, generally somewhere in the home office, maybe in a home safe. Only 17% of people store stuff on their computers, and about the same on USB devices. And then a very small proportion of people are putting their crypto asset keys or seed phrases and documenting them, putting them in a safety deposit box, which is quite shocking, as people have tended to put jewelry and gold and other types of assets in safety deposit boxes in the past. So I want to kind of look at what some of the risks are. And Jason covered some of these things, but I wanted to sort of go back and sort of dramatize them a little bit. So the first thing is you must have an inventory. So that's one of the biggest tasks that end up happening after investor passes away, is figuring out where are all the assets, what are they, and then how do I get access to them. So not only do you need an inventory, the inventory needs to be bang up to date. And while in the last couple of years, maybe it's been very clear that you're investing in Bitcoin, you're investing in Ethereum, all of a sudden this year we sort of entered into this phase where people are investing in all kinds of coins. The whole DeFi area has created a rush to invest in lots of different types of assets. And so it's important that all of those assets are in fact accounted for. So having an up-to-date inventory is very, very critical. The second thing then is, because of the nature of digital assets and cryptocurrency, you need pretty detailed instructions of how to access those assets wherever they happen to be. They might be on an exchange, hopefully not, because very often we see those exchanges getting hacked, but they might be inside a software wallet, or they might be inside a hardware wallet. And both software and hardware wallets have complex procedures to access wallets or reinitialize wallets if you want to access them. So having the instructions is really important. Being able to find the instructions is very important. And of course, the instructions need to be readable. So that's, all three of those things are very, very important in terms of, once you have the key, you kind of know what to do with it. The third aspect is kind of relating to the fact that many people will create an inventory and will document, and then that information gets passed on to a number of people down the chain. It could be lawyers, it could be other professionals that are involved in the planning process. And unfortunately, what that means is that a lot of times information regarding your assets is sort of floating around, and it's not necessarily always 100% private. And it really does need to be. Many people talk about multi-signature wallets, those kinds of scenarios where 3 people can have access to the wallet. And that is a great idea. The one disadvantage in this particular area is that people who participate in a multi-signature scheme can see what the assets are. And so in a sense, you're leaking what your future bequests may be. And that, in certain circumstances could lead to inappropriate behavior. And then the fourth thing I wanted to kind of dramatize was safety deposit boxes. We've all grown up with safety deposit boxes, but they are the first thing to get boosted when there's a bank heist. But more seriously, this year with the pandemic, I think we started to see the failing of physical centralized storage, in that you couldn't necessarily get into all the banks all the time. I mean, you still can't get into the bank, the safety deposit vaults all the time. You can get into them when the bank is open. Safety deposit boxes often are moved around, reordered, etc. And sometimes things get stolen, and sometimes things get misplaced. And so again, if that's where you stored your private keys, you're not necessarily going to be recompensed for that. In fact, the insurance on safety deposit boxes is I think limited to not much more than $500. So the most famous people to use safety deposit boxes are the Winklevoss brothers, who are actually investors in Vault12. But anyway, I'm going to talk about what they did. So they took their private keys, they cut them up into strips, put each strip inside a safety deposit box at a regional bank that was 30 minutes from the airport. And then both of them flew around the country and deposited these strips inside safety deposit boxes. And that's great. That's very secure. These guys are not selling their crypto. They're in it for the long term. But if you think about a pandemic scenario when they actually want to retrieve that, I'm sorry, if they want to retrieve that in the case of a pandemic, that could be pretty complicated. So safety deposit boxes are not the be all and end all, unfortunately. So now I'm going to talk about what Vault12 does. And I'm just going to highlight kind of where we created a simple process to make it easier to make sure that you have an inventory, that it is up to date, and that there is a very simple and easy, direct way to transfer the assets from one person to another. And that your assets and that process of transferring the assets is kept completely private, so that no one really knows what those assets are except yourself. Jason introduced kind of some of the terminology around trust and estates, and we're going to talk about beneficiaries and executors and trustees, because they all have a different role to play in the legal process. But in the Vault12 process, all that's required is to designate an individual who will receive access to the assets. And then what they do with the assets is governed by your trust or your will or whatever the legal framework is governing your estate. So it's a very simple process. You create a digital vault, basically a digital safety deposit box. You add assets to it. And adding an asset is as simple as typing in the seed phrase. And then you designate a set of guardians who will guard that vault. And the purpose of the guardians is they're people that you know. So you're not dealing with impersonation or any of those kinds of things with anonymous participants. They're people that you know and trust. They could be professionals that you know and trust. So they could be your lawyer, could be your wealth manager. And what happens to the actual digital asset is that it gets encrypted and split and distributed to those people. So they get a piece of it. And so you might do this with 10 guardians or 20 guardians. Those guardians can also be devices. And none of those people actually know what they're guarding, unless you are explicit in the description. So it can hide your assets for you from that perspective. So the idea is that as you buy new assets and you get new wallets and you have new private keys on different services, you record those inside the vault. They go in the vault. Then not only is there an inventory that's up to date, but everything is captured in there in real time. The digital inheritance process, very simple. You choose one of the guardians. It could be a son or a daughter or an uncle or an aunt. And that person will be the person who will ultimately get access to the digital assets. They'll get access to the keys or the seed phrases and be able to open those assets and distribute them. The process is very simple. We wanted to sort of have something that declared who the designated individual was in a declaration. So once you've designated the beneficiary, the app will generate an agreement for you that you sign, and then that can be sent to your lawyer. It can be sent on to the beneficiary and anyone else. So that records your intent to pass on those assets to this particular person. And again, it's passing on access to the assets. Who ultimately gets the assets really should be described in your legal documents. And then when the time comes and the beneficiary or the designated guardian needs to activate inheritance and get access to those assets, it's a very simple process. They activate the transfer, and obviously there's a couple of scenarios where this might happen. Obviously, the scenario that we're talking about today is when someone is deceased, but you could be incapacitated, you could be incarcerated. So there are maybe some other examples where a beneficiary might activate inheritance. So we added some safeguards, and the safeguards include making sure that the communication between people is not sort of via some messaging app, that it happens because you've picked up the phone and called them. So you need to know who your guardians are. But when a vault is activated, the owner also gets a notification. So if someone decides to try to get access to your assets before you're ready, you can cancel the transaction if you're around to do that. So the key thing in our system is really picking the right guardians. And we're going to have a little Q&A session in a minute. And I think some of the more complex scenarios that end up getting discussed revolve around choosing enough guardians, and then choosing the right number of guardians that need to issue approvals, which could be 5 out of 10 or 3 out of 20, and making sure that you pick the right kind of people that will be able to do, carry out your intentions, essentially. And this could involve everything from making sure you have guardians all around the world, to making sure that your lawyer is part of that group, making sure that there's a couple of devices that are set up as guardians that you control and keep in a safe at home, any and all of those scenarios. So once inheritance is activated, the beneficiary, in this case, it's this young lady here, Dana, who you'll see in the videos that we've made. She will need to contact the guardians, and they will go through kind of an approval process where they swipe to agree that someone is trying to, or the right person is trying to access the assets, and then the assets are recovered. And it's basically as simple as that. It's a very simple approach to directly getting assets to the designated individual. This process is perfect for those scenarios where you have a lot of assets or a lot of changing assets. So you get to have an up-to-date inventory. It's completely private, and it's very direct. And if you want to change the beneficiary or the designated person, you can change it. it is not a replacement for your estate planning. It's not a replacement for your will, although you might want to store your will or a copy of your will in your digital vault. But it works in conjunction with your digital estate planning, and actually all of your estate planning that can be even more complex. So very easy to try this out. You can download the app on vault12.com, and you can sign up for a subscription, and then you get a free trial, and you can try out and see how the whole system works. So very, very easy. And we'll send you, as a follow-up, we'll send you some videos so you can see the whole process in action. Great. So now, Phil, let's why don't you unmute yourself, and then let's have a little conversation.
Okay.
So Phil has been working with Vault12. He is our crypto lawyer, and he has extensive experience both in the legal area, M&As. He has worked with a number of blockchain digital asset companies, both on helping them list digital assets, as well as working on legislation that has gone through Congress. So I'm going to let you actually expand on that intro, Phil, and then we can talk about some real life scenarios.
Okay, well, thanks, Wasim, for that introduction. And my name is Phil Berg, and I'm a partner at Otterberg in New York City, and also the chairman of their corporate department and the privacy and cybersecurity practice group. And my interest in the crypto space is a product of having been in the cybersecurity piece of our corporate practice, and it has expanded into the areas that Wasim mentioned, and we've also tried to be a partner with regulators and the U.S. Congress in trying to help move some kind of legislation through or regulatory clarifications in the United States, which would be quite helpful in making sure that investment in this DeFi industry and in the crypto space continues in the United States, which does suffer a bit from having this regulated on a state-by-state basis, or simply by the SEC's enforcement actions. So that has been interesting. And I guess with that, I'll leave it to Wasim to pick up on the questions.
Great, thanks so much, Phil. So so I've just gone through kind of a product presentation, and Jason at the beginning kind of went through kind of the landscape of what's involved. And I thought we should talk a little bit about kind of some real human scenarios of what really happens. And I don't know if you want to use yourself as an example, but how do you think? I mean, you know Vault12 pretty well, so how do you think people are actually going to go about using this?
Well, as Jason mentioned, when something happens to someone and they die or incapacitated, it's the garnering, the marshaling of assets, and figuring out what's out there and figure out how to access those assets, which is the most complex part, and it's very much more so in its complexity when you're dealing with digital assets, because real estate assets, there's one centralized ledger on which a record of those assets is kept, and it's easy to get there, figure out who owns it and the boundaries of that property. And in financial assets kept with banks and things, a trustee or executor could merely check the mail of the person who's passed, and you'd eventually get monthly statements, et cetera, and be able to figure that out. Now with digital assets, there's no there's no record on a public blockchain of who owns what assets on that blockchain. And so without some place that just makes all of this available and then keeps it secure until the time after the person has passed, and then allows a mechanism for moving it to the appropriate person, either the beneficiary or the person who's going to be the executor to deal with the will. Without that, there's a good chance that some of these assets could be lost or not accessible. JP Morgan just recently came out saying that this is a very important asset class that that should be seen as an alternative, such a store of value, such as the way we treat gold now. So this could become increasingly important, and gold is generally easy to find in a safety deposit box wherever you might have it, and digital assets not so much. So in my case, having purchased some Bitcoin back in the day, and as it becomes more valuable, you have it in this in your vault, and you would have a will that would kind of direct where you would like this to go, and would also say who the responsible person is after you pass for making sure that that's where it goes. And so I have the choice then that I would either pass it directly, give access to those assets directly to my partner, the beneficiary, or pass those on to my little brother, who's named in the will to as the executor, so that he can protect them while we go through the probate process and eventually pass them on to my partner. Now, if I get more complicated in estate planning with trusts and things, then it would be a simple renaming of the beneficiary, and were there to be a dispute among family members or beneficiaries or whatever, because multiple people would say, well, I was named the beneficiary with this declaration. Obviously, the one that has the latest date would be the one that the probate court would presumably honor.
Yeah, I mean, you raise an interesting point, which is at some point in your life, you may set things up one way, and then later, as your circumstances change, you may want to, have a will that's has a more complex nature to it, and so you may be changing, who the designated guardian is, or who the actual beneficiary is of the will, and so this solution, in conjunction with your will, really defines who those people are, and they don't have to be the same person. But you do need to think about what's defined in the will and what's defined in the app, because one is simply a transfer and the other is a legal framework for dealing with your estate.
Yes, and one of the aspects of this that you had mentioned earlier is the digital information that's stored in your vault does not exist on any of the guardians or your own single device. It's been sharded in a way that there is a minimum number of pieces of shards that have to somehow come together through the voluntary actions of that number of guardians for that information to be reconstituted. And without that threshold number, each of the people holding their Vault12 device has absolutely zero chance of getting any of the information. But the minute that the minimum number of shards come together, then 100% of the information becomes accessible. So it's just it's very much a way that protects the privacy and protects accessibility, which are in the cybersecurity field. People forget about accessibility sometimes. You may have a really hard lockdown servers at your law firm or whatever, and so you protected privacy, but then there's a knockout of the power there in the building, and no one can do their work for 5 days as they try and reconstruct this. And lawyers these days do all of their work on using the computer. That accessibility is a security concern just as powerfully. So the balance of accessibility, privacy, and security with this particular solution seems to pretty squarely fit this unique fact set that we have when we're dealing with digital assets being inherited.
Great. So, Jason, why don't you come and join us, and then let's have a look at some of the questions. There's quite a few questions that have come in. If you have any other questions, please definitely post them, and we'll try to get through them. We have a few minutes to kind of cover those things. So I think this first scenario of, is a will still required? Can this be used with a living trust? Do I need to consult a lawyer? The answer to those questions is absolutely yes. This is not a legal document or a replacement for the legal planning and legal implementation that needs to be done. Jason, perhaps you can, I think you mentioned this at the beginning in your intro. Can the beneficiary be the executor or trustee, or is it only the beneficiary? Like where does it fit? And what are these different roles? Maybe
Sure. So generally speaking, when we set up a trust, just to give an example, there are a few different permutations here, but a simple trust, I create a document, which is essentially a set of instructions, 40 or 50 pages, contains all of the rights and obligations of a trustee. The trustee is a third party, could be my spouse, could be my brother. In some instances, it could be myself, where there's a set of instructions that lays out how I want the assets to be administered. The beneficiaries of that trust are the people who benefit from it. Accordingly, the trustee, as I noted, is a fiduciary. The trustee has a legal obligation, an enforceable obligation, can be sued by the beneficiaries. If you are setting up a trust with cryptocurrency, which is increasingly becoming common, what you need to do is make sure that there's absolutely no gap in understanding that the title to the assets is being conveyed to the trustee in his capacity or her capacity as a trustee. You don't want any sort of question or discrepancy when it comes to, am I giving my friend who is the trustee these assets for himself or herself, or am I giving it to them as qua trustee? The way you would do this is you'd need to set forth in a document, presumably in the trust instrument, or you could use some other conveyance instrument such as an assignment, to make very clear that those assets are coming in. And as I pointed out earlier, you're not dealing with an asset that has a legal title in a traditional sense. If I want to give my home to a trust, I want to create a trust for the benefit of my kids, and I want to make a gift of a home that I have out in the Hamptons. It's a relatively simple matter to retitle that home using a deed, put it into an entity form or directly in the name of such and such person as trustee of such and such trust. You can't easily do that with cryptocurrency. And so the first thing that's necessary is some sort of document of title, simple assignment that would be done. The second thing is on the technological end, you must make sure that whatever Vault12 has on record dovetails exactly with those instructions. And so that would be a matter of accessing the technology and making sure that it's correct and that it's up to date. As you mentioned, one of the challenges is these things change over time. And so we often have people who set up trusts, they name a trustee, down the road, things change, the trustee is no longer competent, or there's a falling out, and they change trustees. And so it would be necessary to change the Vault12 documentation to make sure, again, there's no lacuna, that there's an exact dovetail between those documents.
Great. So there's quite a few questions in the Q&A box. So I'm going to go through most of them are related to Vault12 products. I'm going to just run through them very quickly, and then we'll come back and talk about, one of you can talk about tax. We're out of that. We're not involved in that process. I'll tell you that now. Okay. So let's see. What is the ideal number of guardians? Does this recommendation vary depending on the amount of digital assets I own? So this is a really good question. And the answer to this is going to be different for each of you. For basic casual crypto investors, it could be as simple as 10 guardians, 5 of whom give the approval. That's one of the defaults. But you could have as little as 5 guardians and 3 giving the approval. But for larger, it's not really the magnitude of the assets that you're storing. It's about how security conscious you are, and what is your tolerance to risk. But let's say that you have a wallet that has a lot of Bitcoin in there, and you want to protect it, and you want to do as much as possible to make sure it remains secure, but that at the right moment, whether it's you trying to access it or whether it's your beneficiary, that no matter what, they can get access to it, which is a critical thing, especially when dealing with high net worth individuals. So in that scenario, the vault can handle 20 or more guardians, and then you get to select the threshold number of how many approvals you need. And so in talking with your T&E lawyer, as you do your estate planning, you need to think through, well, how many of these devices, maybe I should have 5, if 5 is the number of approvals you need, maybe I should have 5 devices in a safety deposit box. Those devices could be, it could be a tablet, it could be old iPhones, it could be just any Android or iOS device that you have lying around. And so I have two iPhone 5Ss that I use as devices. And what that means is you have control over those devices. So you don't need to talk to anyone else to get an unlock or to get a vault recovery. But these need to stay somewhere very, very safe. So maybe they are in a safety deposit box. And the key to the safety deposit box is with your executor. The other guardians, the remaining 15, maybe 5 of them should be family members, close family members, and another 5 could be trusted business contacts, and another 5 could be, friends of yours. So you've distributed the protection of your vault amongst several groups that are trusted to you or have some trust as part of them and known to you. And that way you reduce your risks of ending up in a scenario where you can't obtain the necessary confirmations. So that's kind of the long answer to the ideal number of guardians. It really does depend, and you need to think through scenarios of what will happen in the future when you want to access, and how many people do you need to go to get approval. Let's see. Is it possible to set certain conditions for when the digital inheritance can take place? If, for example, I haven't logged in for 1 year, then is it possible for digital inheritance to automatically take place? We haven't implemented that at this time because it really is unclear what those trigger points could be. I think for the incarceration scenario, it makes sense that if no one's heard from the owner for 6 months, that it might be something that gets automatically triggered, but it's something that the technology could support in the future. Let's see. Does Vault12 support all cryptocurrencies, Bitcoin, Ethereum, etc.? So the Vault itself is not tied to in any way to what the digital asset is. So it could be anything. It could be your medical report. It could be your AD. It could be your bank account passwords. It could be your private key or your seed phrase. So it's completely independent. And the Vault is not, does not have custody of your assets. So it simply contains the access credentials for accessing that digital asset. So what is maybe Jason, you could address this. What is the scenario when you just have a will and it states in the will your digital assets are at an exchange? Can the executor contact the exchange?
That's a good question. So it varies by state. Some states, as I mentioned, have put into place legislation to deal with this issue. What they say generally is you've got the ability as an executor to access any digital asset that was owned by the decedent. That is a rather forward-thinking approach. Many states don't have this in place. In those states, you'd have to kind of reference the law. You'd have to take a look at what's happened in the case law, whether you'd have grounds to access it. The basic way of looking at cryptocurrency stored on an exchange is that it's nothing more than an asset owned by the decedent, and all assets are subject to the dominion or the control of the executor. But again, it's not necessarily going to happen without a fight, and it's not necessarily a foregone conclusion. So you have to reference the state law.
Great. Do you want to cover the tax, or Phil, do you want to cover the tax question, which is how are these assets handled for inheritance tax purposes when they're passed on? My answer from Vault12's perspective is we're independent of it. Lawyers have to deal with that.
Sure. So from an inheritance tax perspective, what I take that to mean is the estate tax. Just by way of general background, each state is entitled to impose an estate tax. Some states do, some states don't. New York, for example, has an estate tax. New Jersey does not. Florida does not. Other states don't. The estate tax on the federal level is imposed regardless of what state you live in. Without going into the details, roughly $11 million of assets will put you into the estate tax taxable category. So if you got less than that, you generally don't have an issue at the federal level. States, again, vary. From an inheritance or estate tax perspective, it's very clear that these digital assets are assets. They are to be accounted for on a Form 706, which is a tax filing that's prepared in connection with the estate tax. It's very clear that it would be valued at the value as of the date of death. So you'd figure out exactly how much it's worth in US dollars on the date that somebody dies, and that would be the number that goes on the return. Unfortunately, there's no way to avoid that result. What I can tell you is there are certain measures that are taken in order to maximize tax savings. And so you can create certain trusts, you can do various things to make sure that those assets don't get taxed sooner rather than later, and that certain exemptions that you do have can be applied for the long-term benefit of children. Sometimes this would involve gifting, it would involve creating a trust in some other state. Sometimes, for example, a state like Delaware has a statute that allows a trust to exist in perpetuity. Other states, Florida, you've got a 360-year rule against perpetuities. So you can do things essentially to make lifetime gifts and do other planning to help to limit your estate tax exposure. But to answer the question directly, yes, all of the principal value of your assets at your death are included.
Great. Okay, so we are actually out of time, so we're going to end it there. Thank you so much, Jason. Thank you so much, Phil. I'm going to hand it back to Patrick, and just that there are quite a few questions. We really appreciate the engagement. I will go back and answer each of them, and get you answers kind of via email.
Thanks, Wasim, Jason, Phil. That was a really impressive conversation, and there's clear demand for it to continue based on the amount of questions coming in here. To enable that, what I'm going to do following this call is we will send out a recording of this call to this list, as well as a broader list of registrants. And then we have a list of resources that Wasim has provided that can help to address some of those questions. But more importantly, we'll also provide the information to kind of connect with the speakers here afterwards. If one, you want to learn more about Vault12, Wasim's obviously a wonderful point of contact there. And if you're looking for additional legal advice in the space, both Phil and Jason can make themselves available. So we really appreciate everyone taking almost an hour to hang with us this afternoon, and hope that you thoroughly enjoy the remainder of your days. Thank you.